Welcome to Direct Effect, Croatia's first EU law podcast. My name is Martin Stier, and for today's episode, I have the privilege of talking to one of the judges of the Court of Justice of the European Union, Judge Siniša Rodin. Judge Rodin, welcome to the podcast.
Thank you for inviting me.
Now, preparing for this episode, I've talked with Professor Bačić Selanec, that you will know.
Of course, yeah.
Because everybody mentioned and everybody warned me that I'm not allowed to ask you any questions. Actually, I'm allowed to ask you any questions, but you're not allowed to answer any questions regarding any ongoing case. So I thought maybe we could do the second part regarding more questions regarding methodology and judicial philosophy. And for the first part, something more surrounding about your life, your job as an academic, and then later as a judge. And when I was preparing for this episode, Professor Bačić Selanec told me that there exists an inside joke within the Department of EU Law that they call you the founding father of the department. So I thought we could start with that. I know you've first worked as a constitutional law professor, right?
Right.
So how did the idea to start the Department of EU Law begin?
Well, the history actually starts a bit before that. On my third year of law degree studies, I took part, and I think it was the first time anyone from the law school ever did that. So Professor Vukas, late Professor Vukas, started to train students for the Telders International Law Moot Court competition. And there was a team of students. I was a member of the team. The remaining three were Bojan Fras, who is now vice governor of the National Bank of Croatia. Then Barbara Novosel, who works as a practicing lawyer in Paris. And Marko Benčić, who works as a judge here in Zagreb. So the four of us, we were a team. We went to The Hague, where the finals of the competition were organized. We met people, and you should try to imagine those times when everything was much more closed and no communication with the outer world, Yugoslavia, communism, this, that. So this was the first time we had some real touch with foreign students, with foreign professors, with world of law outside what we were learning here. And that's how it started. So the next step was to found ELSA. ELSA, European Law Students Association. Again, the four of us. Why? Because we met people from ELSA in The Hague. So we thought, well, let's do it. This was something unheard of because all student organizations were somehow anchored to this communist infrastructure, socialist youth, or whatever. So it was virtually impossible to organize anything outside of that framework, and we did, actually. So ELSA Zagreb, I think it was called ELSA Zagreb. It was known national ELSA. We were the only association in the country, and we started working on that. We organized the European Council meeting, which took place in Zagreb. We met more people, and so gradually we developed a network of colleagues. We started to reach out of the boundaries of the law faculty of the country, if you will. So then I graduated. I started to work at the court as a trainee, and at one moment there was an opening at the law faculty for a position of assistant, which I applied for. I was employed. It was constitutional law department, and that's how I started with constitutional law. But then, restless as I am, I was looking for things beyond that. I came across a book on one of my travels, Lasok and Bridge, European Community Law. Mm-hmm. This was like rocket science at the time. Nobody even cared about it or knew about it. So I was fascinated by the book, and then that's how it started. So then, much later, I was already, I don't really recall the actual year, But at that time, the law program, the law degree program was a little bit rigid. There were not so many electives, and everything was more or less given. But it was possible to have an elective course. Nobody really wanted to do that. You know how the lectures were being held. You know, I think Professor Kurtovic was one of the few who really wanted to have lectures instead of not having them.
Yeah, I mean, we didn't have Professor Kurtovic, but we heard stories.
yeah, he's a legend. Yeah, and anyway, so I applied for an elective course, and I think again nobody really took it for serious, because you know when you are permitted to have an elective course, nobody really expects you to have a class. I don't know why they even thought we should have elective courses like that. But I applied, and the faculty approved, and this was European Community Law, as it was called at the time. And I started to really have classes, and I had real students, and then we would have like one meeting a week, 2 hours. And this was great. It was really something that I wanted to do, I loved to do, and that's how it all started. Then, at one point, that must have been in 2001, I was on my Harvard grant in Boston, and at Harvard, and I applied for EU funding for teaching EU law, and I got EU funding, and that was a big deal, and it was not a whole lot of money. It was well, looking backwards, just enough to start doing something. And I was at Harvard, and then I got the grant, and then I had to get started. And I needed someone actually to replace me in my teaching on my elective course. So Tamara Čapeta, who is now Advocate General at the Court of Justice, she's my friend since then, or even before that. So I called her. She was working at the Faculty of Economics. I said, "Could you replace me while I'm in the United States?" And she was happy to do that. So it was 2 of us then at the time. And that's the time when it started really rolling in 2001, 2002. And then, actually, I don't even remember when was the formal decision to have a chair in EU law. When was that adopted as a decision? But in any case, I remember we had a debate. We had a debate how this chair, the newly established chair, should be called. Because, well, I'm not really a big fan of this public-private divide. I think public and private law intersect at many points. But there were colleagues teaching civil law and civil procedure, and they said, "Well, you should actually teach European public law." I said, "Okay, not everything is in the name. Let's call it whatever you want." So it was European public law, and I think there was some kind of afterthought, that one day someone would wish to have a chair in European private law. And artificial as it is, this division never really lived up. I mean, how can you explain basic concepts of EU law like direct effect, horizontal direct effect? It's all intertwined with between public and private. But so be it. We started with European public law, and it's until the day it's European public law.
I think you emphasize on something that is pretty important and something that is happening at this moment in Croatia, which is, as you said, once you started going to the moot courts and being more and more exposed to European law, it changes the way that you view the law. And it's something that is especially coming from a system that was a rigid communist system. Did, in your case, first of all, European law, in which manners, change the way that you view the law? And do you think that there's, within the Croatian judicial structure, do you think that there's a movement of change in the way that judges understand the way that to interpret the law, to read the law, different methodological yeah.
Well, I have to go back in history again. Well, I graduated. I started to work as assistant in constitutional law department, and my professor, it was Professor Sokol, he told me immediately, look, you will have a seminar, so you will teach a seminar once a week, whatever. And those students at the seminar, they were my colleagues. I was sitting in the same bench with them for years. Some of them, didn't graduate yet, but basically, it was the people I knew from the faculty. And the other thing is, I really didn't feel comfortable teaching. I said, look, I just graduated. What should I do? I'm no smarter than anyone else. So why would I have to say something or anything to the others? So I was really unhappy with my work, with what I was supposed to do, and well, I was supposed to basically to retell the book knowledge, which was completely insufficient for me. So I was trying, and again, you should imagine those times where there was no way how you could get a chance to study abroad. But I wanted to go for a master somewhere, and I was applying for years. I was already on my postgraduate program. I did my master here. That was called scientific master at the time. And I was still searching for a place to study. And then, boom, it was not by accident, but well, anyway, I was admitted to University of Michigan for 1 year master program. And that was in 91, 92. And this 1 year of studying in the United States completely transformed me as a lawyer, as a person, and as anything I am. Why? Well, first, it was a completely different approach to teaching. During the first semester, I didn't know what to do. I was bombarded by reading and materials that I was supposed to study, and I said, "Look, there's no way I could learn anything from this. It's so heavy, so many pages to read, and no way I can learn that." And then I talked to American students. I said, "Look, what are you supposed to turn in as an exam? How do you approach the exam?" I said, well, don't worry, you just do your reading, you think about it, you try to make sense out of it, and then you go for the exam, and that's it, And the exam, well, not one, but many, they were usually, not all of them, but usually they were like 4-hour in-class open book exam. Open book exam. What's the open book exam? That's something. And then at one point it clicked. That you were supposed to understand things. You're supposed to make sense out of things, not to memorize things, which is impossible. American law schools are preparing students for real life, where every day brings a new legal problem that you have to approach, address, analyze. And not some book knowledge that you need to know. So after this first shock during the first semester, I said, "Oh, okay, that's it," and then everything went fine. Everything was great, but it was deeply transformative for my personal development. And then I came back to Zagreb at university. I continued. This was all before the department was established. And I met a colleague on the stairs of the faculty. Well, doesn't matter who that was. He was very friendly to me. Oh, you are back from the United States. How? I said, well, I've learned a lot. I said, well, but wouldn't you say that legal education in the States is not any better than what we have here? I said, yeah, you're right. Have a nice day. See you later. So, because my impression is that what I've learned in 1 year in the United States was so much more and so much more valuable than what I've learned here during 4 years of law degree program. I still, when I think back today, it's a miracle, and I'm grateful, to University of Michigan and my professors there, and it really deeply changed the way I looked at law and life and everything. So back to EU law, then I started to apply what I've learned in the United States, and I had open book exams. I had reading assignments for students. I expected students to discuss that in class, Socratic method, as you call it. So it was completely different. And then I realized, that the students are somehow not prepared to receive all that. You have a group of 100 students. Among them, maybe 10 of them, are ready. The next 90 are not. But then again, and that was my thought. Look, those who are really good, they will make it on their own. Those who are really bad, they'll never make it anyway. So what you need to do as a professor, you need to focus on that middle class of students, those who have a chance to make a progress, but you need to help them somehow. And that's what I was doing, and that's, I think, the only way to go. Of course, you cannot neglect anyone. You don't make any difference among students. But still, the biggest reward is when you manage to make some students progress because of you, not because they are smart on their own, but because you help them out.
Which I think is probably the most rewarding part of being a professor.
Oh yes, and I still miss it. As a judge. Yeah.
I know that Professor Bajic mentioned she holds the European constitutional law classes at the faculty, and one of the things she mentions, because she also went to Michigan, is how much understanding the American way in which they view the law actually helped her understand the way in which EU law is to be understood. And yeah. Well, but that's kind of a very tricky assumption, which I was victim of myself. I was appointed to the court now a bit more than 10 years ago. Now I'm really, well established there. I know a lot of things about how the court works and how people think. And in no way I could have assumed that law in Europe is so similar to law in Zagreb, in Croatia. That's simply something that I didn't expect. The way of thinking, and it's not really palpable. Or maybe it is once you give it a thought. So let's put it this way. Lawyers in Europe, academic lawyers, practicing lawyers, they have certain approach, you can call it normativist approach, whereas where law functions only within certain framework of rules,
which is separated from real life. So whatever happens in real life is secondary. Of course, these are the facts or context of law, context within which law operates. But there is always this primacy of rules. So whenever you interpret law, you interpret rules, you interpret relationships between rules, and then somehow you forget about the real world. My approach, and this is an approach that my colleagues at the court not always understand when I tell them, and I tell them like I tell you. Of course, each case has a multitude of possible approaches how you can attack it, how you can approach a case. And it's job of a judge to decide which way to go, which approach to take, and then where to lead the case, and by what means. How do you do that? Of course, you need to choose applicable law. You have to interpret law, but then there's one thing which I ask myself, and that's, I would say, highly unusual for European legal thinking. I always ask myself one question. In a situation where you have multiple approaches or even multiple solutions to a case, when you are aware that law is not something fixed, that there is no fixed meaning, but that everything is actually contingent, and that it's a subject, a person, a judge who can drive a case in one direction or another, then you have to ask a question: what terrible can happen in a real world if you choose one solution over another, one answer over another? And if nothing terrible happens, one way or another, then it doesn't matter. Then you are at liberty to play with legal rules and interpret them in the legal realm. But if you somehow tease out that your decision, however well argued in legal terms, it could be really waterproof to any legal attack. But if it creates some let's say disastrous or detrimental consequences for real people, for real world, then something is not right. And you need to test other possibilities. So when you eliminate all solutions that lead to something terrible happening in the real world, then you are free to do the law.
Yeah, I think this is a great segue to, my next question, which technically seems like a simple question, but I will probably see it isn't. And that's the question of the role of a judge. So is it to simply interpret the law? Or is there space or any justification for creating the law?
Well, that's an old question. That's an old question, whether judges make law or find law. And it hasn't been answered even in common law systems in the United States or UK. There's, especially in the UK, there is still this I would say, prevailing opinion that judges find law and then not make it. But at the end of the day, it doesn't matter. The question is purely academic, I would think, because what judges do, judges decide cases, and every next case requires some kind of evolution of legal thinking, some kind of evolution of rules, because there are no two identical cases. Well, sometimes there are, but we can say safely, there are no identical cases, and every time you need to apply the same law on different facts or different context, then, well, you have to evolve law. You have to somehow twist it or evolve it, develop it in order to fit the new circumstances. And that's, I would say, the most delicate part of what judges do, because you have to, solve the case. You have to find a legal solution that fits without hurting anyone, without doing some damage on another on another end of what you do. But if you ask me, do judges make law? I think, well, yes, they necessarily do. It would be a denial to say that judges don't make law. just we call it differently. In French legal tradition, we call it jurisprudence constante. It's not a precedent, but it comes very close. For all practical purposes, it's almost the same. And without some model of coherence, intellectual model of coherence, be it the precedent, be it jurisprudence constante, you cannot have a coherent legal system. Simply needed.
I mean, how does it come into play regarding the division of powers? I mean, if you say that in your particular situation, you think that judges do create the law, how can it be compatible with the idea of having a legislature, a judicial branch, and an executive branch that are all, in a way, divided in regards of the powers that they have?
Yeah, we have to be very careful. American Supreme Court Justice Scalia, before he passed away, he was considered a very conservative judge. And then he published some good work on theory of interpretation, which is not so dissimilar of the mainstream interpretation which takes place in Europe. We're inclined to think about American ways of interpretation as being very progressive, very liberal, Roe versus Wade, I don't know, liberty, rights derived from liberty. Scalia was more down to earth, and he was considered a conservative because of being down to earth. So what Scalia's interpretive philosophy basically was, he says, well, okay, text. We start from text. There's always text. But then you have to interpret this text, and how do you interpret it? You interpret it in its context and purpose. So EU law, many people would say, is teleological, purposive. So we are supposed, or we actually do, interpret EU law according to its purpose, and purposes are, well, different. Most general purpose would be continental legal integration by law, by trade, by free movement, common competition rules, and so on. And then you have more concrete purposes always in the preamble of legislation, like directives. They have their preambulary text, which says, well, the purpose of this directive is and so on. So, purpose. And this comes to your question, how do we not encroach on competences of the legislative branch, and etc. So back to Scalia, he says, yeah, text, context, and purpose, but purpose cannot be interpreted against the text. So it can be interpreted only in line with the text and with the perspective of giving the text certain meaning, but not against the text. So you cannot pervert the clear meaning of the legal text in order to read in some putative purpose. And I think this solves a lot. This solves a lot, but it requires certain discipline. And then if you look more concretely, well, when we scrutinize legality of acts of the Commission or European Central Bank or whatever institution that we do, the court allows for a large margin of discretion, as we call it. We say when there's a complex economic assessment, then institutions have a wide margin of discretion, and the standard of review would be a manifest error. Only if the institution erred manifestly, then we intervene as a court and well, step in.
Mm-hmm.
In a way, as a kind of constitutional court, when we control legality of a few acts. But then, when it comes to acts of the member states, here, this discretion is much more narrow. Why? Because there is this underlying philosophy of European integration that, well, we are seeking for convergence, not divergence. So when member states restrict trade or impose barriers to trade or do whatever, which runs against some European coherence, then we are much more strict. We normally apply proportionality test, but the width of discretion is not so large as in case of European institutions. And then, well, some people are critical of it. Some authors, criticize this openly. Say we should have the same standards for the institutions and for the member states. Well, but that's the way how the law developed, and then that's the way how it is. I guess the reason behind it is this philosophy of European integration, where we think that the law should serve as a factor of coherence between legal systems.
How would you say that you see the future of integration in Europe?
I don't know. Well, of course, we can speculate. You can say one scenario would be business as usual, and well, we just keep doing things as we did. And let's wait and see what happens. The other scenario would be well. First, we need to look globally, and we need to look at the world and what changes happened in the world over the last 10 years, and the changes are huge. So what happened? Basically, globalization failed. There is no hope for globalization as it was conceived 15 years ago. So, full stop. No globalization. So in such circumstances, what should Europe do? Well, there's no way back. So free trade is going to stay. It's here to stay. Just the question is, free trade with whom? United States, fine. Within the EU, fine. Associated countries, fine. Canada, fine. But then when it comes to some other actors like China and Russia, there are huge question marks. Huge question marks. Look, in the times when the treaty establishing European Economic Community was drafted, there were, of course, from the very outset, there were free movement guarantees, free movement provisions. And what is today Article 63, I think, the free movement of capital, was deliberately left open to third countries. So free movement of capital is guaranteed as a market freedom, not just within the EU, but also with third countries. But then, back then in the 50s, what were which were those third countries? And who had the capital to move in? The United States, realistically, no one else. Maybe UK, but that was it. Today, when you look, what's going on? Russian oligarchs, Chinese investments. So there is a diversity of capital on the global market, and not all of this capital is friendly to the European Union and then to its member states. So one of the things that I think will have to be rethought and reconsidered is to what extent can foreign capital be allowed to flow freely within the EU, knowing how corrosive for democracy it can be.
Mm-hmm. I know, looking more inwards, we had a guest lecture when Gareth Davis came from Vrije University in Amsterdam. And he spoke about the problem where he sees that there's a mismatch between the level of integration that is being either pushed or promoted, depending on how you see it, at the highest levels of the EU, and at the level of working class people. And he emphasized on, first of all, he gave an example of the problems of the internal market, giving the example of Belgium and the universities, let's say, where they have an enormous problem, where they have an influx of French people going to Belgian universities or Dutch people going to Flemish universities in Belgium, which in a way, creates a reaction within the Belgian people and the Belgian students. And he, once again, I say, emphasized that there's certain problems and certain consequences that we see when there's a mismatch between the speed that integration is going on one level and on the other. Would you agree that there is a mismatch in regards to this?
What you're really asking is whether citizens of member states can enjoy the fruits of European integration. Or to put it in other terms, is European integration just a bureaucratic process, bureaucratic phenomenon where everything goes fine on a certain level of decision making and political life, and then when it comes to ordinary citizens, you see a little or no of that benefit. I disagree with this picture. Of course, there is European bureaucracy or bureaucrats and European judges like me, and then the countries like Luxembourg that live very privileged lives because of European Union, not only because of European Union, but largely because of European Union. But I would say, just look at Croatia today and Croatia 10 years ago. And of course, people would lament, about Euro, about Schengen, and so on and so forth. But looking from the outside, looking from now 10 years of my life in Luxembourg, I would say that Croatia benefited a great deal from free movement. And still, we have not exhausted that potential. Look at the tourist industry. How much more easier is to travel to Croatia now with open borders and with single currency, with no need to go to the bank to change the currency. And now we really function as a part of Europe, and that is also transferred on the people and on citizens. Every house rental in Dalmatia benefits from Schengen and Euro in indirect ways, even if they don't see it, like that. So of course, there are obstacles. Those obstacles are not necessarily on a European level. It could be also on national level, on local level. But generally speaking, I think this is visible. I wouldn't overestimate the problem of European bureaucracy, because even if that were a problem, if European politicians were really, considered to be some kind of caste or whatever, look at the results. Instead of fighting wars, European states live in peace since the Second World War. And if this energy is spent on some political process on European level instead of on waging wars, then this is a major success, and we shouldn't be complaining about that.
What is your take on the idea of a multi-speed Europe?
I don't think this is something that we can control. I don't think this is something that can really be managed. It has to be accepted as such, and then somehow addressed in a way that it suits best for all those concerned. Multi-speed Europe. What does it mean? You have the inner circle, Schengen, Euro. Croatia is in now. We are no doubt, the inner circle of Europe. There are countries like Denmark, like Ireland, who are on the side because maybe their geographical position, or Ireland has the issue with borders with England, with UK, so Schengen is a problem for them. Denmark, they have their own currency, so there will always be some kind of differences. But I wouldn't say that I wouldn't call this multi-speed Europe. The question maybe arises in context of enlargement, and now we have all these we have war in Ukraine, we have Brexit, we have an unstable neighborhood, Turkey, which is in customs union since 1963, but then not really getting any closer. So the question is what Europe can do with its neighborhood, but this is another phenomenon. This is not a question of multi-speed Europe.
Mm-hmm.
But this question is also important because Europe needs to have a, let's say, reliable and stable neighborhood.
Yeah. You've mentioned the war in Ukraine, Brexit, and different crises. How do you see it? Do these crises, in your view, make the EU stronger, more integrated, or do they fraction the EU and show some problems within them?
I would say that they pose a challenge which needs to be addressed with more realism. I'll give you an example. We have a problem of refugees. And we all know humanitarian law, Geneva Conventions, EU regulations. So we all know what the law is, what the rights of refugees are, and well, that's pretty much clear. And there's no disagreement on that even. That's well established. But then you have phenomena that refugees are being weaponized by hostile third countries like Belarus, who is bringing refugees to the borders of European Union and sending them across the border, as I can see it, with the purpose of destabilizing Europe, destabilizing the system of asylum, the system of international protection. So this requires some rethinking, and it is not an easy job because you have to stand up to your values, to our own values. You have to stand up to international law, to our own regulation, but at the same time, we should not be naive and just say, why is all this happening to me? It is happening because there are forces across the border which want it to happen. So this calls for a certain level of alert and of naivety, so to say. And yes, it is a challenge. But if we think in terms, what's the best for European Union, what's the best for the member states, what's the best for our own values, I think it's possible to find a solution, which may be different from what we know now, but I think Europe is capable to do that. Look, I mean, there are other challenges also, but the big achievement of the EU is that we have the mechanism for resolving these challenges. We have political process, we have adjudication, so we have the full institutional structure at place. But mind you, this institutional structure is also under attack. It's also being tested by inimical forces. All this institutional distrust, even corruption, which does not happen by chance, is posing a threat for trust in the institution. So I think that the biggest challenge for the EU, but also for the states, is how to re-establish and how to affirm the trust of citizens in the institutions. And that can happen only if the institutions deliver. So institutions simply have to deliver results that are visible.
For our last question, and we did this with our last two guests, this is a student-led podcast. And we tend to finish the podcast asking our guests to give advice to students. Doesn't have to be law students, any type of students. So what would you advise?
Never settle for less. Be curious. Do what you feel you should be doing. Explore. Try to create some added value. don't wait for an employer to find you. Find your own employment, so to say. Be open to new ideas, and be open to information that is coming from different sources. It's messy times. We are flooded with all sorts of information, real and fake. Try to think for yourself, and try to construct your own reality based on your rational thinking, and not on impulses and impressions that are flooding us.
Judge Rodin, it's been a privilege talking to you.
Thank you very much. Thank you very much.
It's a wrap.